have you reserve your time?
Your Honor, yes, I would like to reserve 2 minutes for rebuttal.
Thank you.
Good morning, Your Honors, and may it please the Court. I am Darrell Schaefer, and I, along with my firm, Samples, Jennings, Clem, and Fields, represent the appellant, Industrial Boiler and Mechanical Company, Inc. The issue before the Court is twofold. There are one procedural issue and another, a substantive issue of law. The procedural issue involves the voluntary dismissal rule, Rule 41.01, and whether or not that rule requires the dismissal of an entire complaint when a litigant files a notice of partial voluntary dismissal. The implication of that is if the court has authority to permit, or if a litigant has the authority to voluntarily non-suit single discrete claims of a multi-claim complaint, then the case should be returned back to the trial court, the ruling of the trial court be reversed, and the case allowed to proceed. The second implication is that even if the rule does not contemplate partial dismissal of a single discrete claim of a multi-claim action, then the case should still be returned to the trial court and the ruling of the trial court reversed. Because if the rule does not contemplate that or provide for it, then the purported or attempted voluntary partial non-suit should be ineffective and determined to be a nullity. And, Your Honors, that is the precise issue that is before the court on non-suit. The second issue is whether or not the trial court erred by recognizing for the first time in Tennessee the independent tort of spoliation of evidence. And what I intend to show the court today is that the court's recognition of that tort did not occur in a vacuum, that the specific facts of this case procedurally warranted the recognition of that tort, and public policy reasons support the court's determination in terms of its recognition of a tort of spoliation, as other courts have done in this country. So although these issues are predominantly questions of law for the court to decide, it would be beneficial to provide the court with some factual history in terms of procedure. So on March 28, 2022, the appellant filed a second amended complaint. This second amended complaint contained 6 distinct causes of action. Number 1, violations of the Tennessee Uniform Trade Secrets Act. Number 2, tortious interference with contract. Number 3, civil conspiracy to steal trade secrets. Number 4, the tort claim of spoliation of evidence. And number 5, the equitable remedy of piercing the corporate veil. On April 22nd, 2022, the appellees filed their first motion to dismiss. It wasn't the first motion to dismiss filed in the case that if the case were viewed in the entirety, but this was the first motion to dismiss that's relevant to the issues before the court. And in that motion to dismiss, the appellee made 2 arguments. Number 1, that the appellant's civil conspiracy claim, and again, that civil conspiracy claim was on the theft of trade secrets, that civil conspiracy claim was preempted by the Tennessee Uniform Trade Secrets Act. And they were right. That is true. The second argument that they made is that Tennessee has not recognized an independent tort of spoliation of evidence. That is also true. Number 2, I want to bring to the court's attention that the appellant acknowledged prior to the hearing on the motion to dismiss that its Trade Secrets Act claim preempted its civil conspiracy tort claim because they were based on the same common nexus of facts. And that is how we determine preemption as it applies to the Trade Secrets Act. So then on June 8, 2022, acknowledging and making this concession, the appellant filed the notice of partial voluntary dismissal. And I want to read the language of the notice for the benefit of the court, because the language is of crucial importance in what the appellant purported to dismiss. And I'm quoting from the notice. Plaintiff hereby provides notice of its voluntary dismissal only of its claim of the tort of civil conspiracy as against all defendants to unlawfully acquire and use plaintiff's trade secrets. The notice goes on to state, quote, all other claims set forth in plaintiff's second amended complaint remain intact and are not dismissed by this notice, including but not limited to plaintiff's claims arising under the Tennessee Uniform Trade Secrets Act. Then later that day, on June 8, 2022, Chancellor Atherton entered the order of partial dismissal. That order mirrored the language, as they often do, of the notice of partial dismissal. And that order expressly stated, quote, that all other claims set forth in plaintiff's second amended complaint remain intact at this time and are not dismissed by this order, including but not limited to plaintiff's claims arising under the Tennessee Uniform Trade Secrets Act. And that's at volume 1 of the record, pages 50 to 51. The hearing took place on June 9, 2022. Now, what's important to note is that at this hearing on the motion to dismiss, the issue of the partial non-suit came up only very briefly. The vast, I would say 99% of the time spent at the hearing was devoted to the argument on the tort of spoliation. And that was because at the beginning of the hearing, the court acknowledged that an order of dismissal had been entered. The court, probably within the context of the filings made by the parties, there being a motion to dismiss the claim that the appellant voluntarily dismissed, the court interpreted that order to be an agreed order. Now, is it an agreed order in the sense that it is signed by both parties? No, it is not, and we'll acknowledge that. But it was agreed in the sense that it was a concession. The appellant acknowledged the fact that its claim was preempted and that it could not proceed with both claims, both the Tennessee Uniform Trade Secrets Act claim and the civil conspiracy claim. So the court entered its ruling and found that the issue of spoliation was recognizable as a tort under these specific circumstances, and adopted the New Mexico case of Eddie Potash, which we'll discuss shortly. And then the parties engaged in discovery efforts, which kind of, in essence, was a big part of what plagued this case, and was the primary reason why this tort was added for the first time in that second amended complaint. So the appellees, months later, filed a motion to dismiss on the basis of Rule 41.01. This is well after 30 days. Even after the appellees filed a motion for interlocutory appeal to this court, which this court declined to take up. They appealed it to the Supreme Court. The Supreme Court likewise declined to take it up. So after the appeals, they filed the second motion to dismiss. And they filed this based on an argument that when the plaintiff attempted to partially dismiss its cause of action, and I should say, when it dismissed its discrete claim of civil conspiracy, that somehow this affected a complete dismissal of the entire complaint. That has never been held. That result has never been found by any Tennessee court, at least in any case of record that I've been able to find. So there are two things that factor into this that I would respectfully ask the court to consider. And the first one is that public policy in our state, in the way that the courts interpret the rules of civil procedure, are to not dismiss cases based on procedural technicalities. And a lot of times this phrase gets thrown around, and rarely, does it really take great effect. But I would say that this is that kind of case where that public policy comes into sharp relief. So there are two bases that the appellant or that the appellee uses to form its argument. The first is that the Justice versus Crafty construction case and the later case of Stinson that was based on justice, that the court in those cases dismissed an entire complaint based on the dismissal of part of an action. But you have to dive deeper into justice and Stinson.
In your course of research, and have you cited to us any cases that said that the claim of spoliation is a separate standalone claim?
There are no Tennessee cases, Your Honor, that state that. The case that was relied upon by the trial court is a New Mexico case, which adopted it for the first time, and it's the Eddie Potash case. And in that case, it's cited at 905 Pacific 2nd, 185. The court in New Mexico, the New Mexico Supreme Court, stated that there were 6 elements of this specific tort, and that under those 6 elements, that a plaintiff could assert what is called a first-party spoliation claim, where a party, a litigant in a case, or a person who is a potential defendant in a case intentionally destroys evidence, and then.
But why would we need that here when we have all remedies available when there is spoliation just under our general spoliation doctrine?
That is an excellent question, Your Honor. And the reason is that while our Rules 37 sanctions do provide some relief to a plaintiff through, most powerfully, a negative inference instruction that's provided to the jury, it does fall short of providing a complete remedy. And the reason is that it is only an inference. A defendant who has committed spoliation is free to rebut the inference to the jury.
But the trial court's not limited to that. I mean, isn't the trial court free to fashion whatever remedy for spoliation is appropriate?
Your Honor, I would say that Your Honor is correct, that the court would have discretion, although
including a dismissal of a claim, including a finding in favor of a claim, including you can't put on any defenses at all, which basically is establishing the plaintiff's claim.
That's correct, Your Honor. But I think that one thing that is important to note with respect to that is that if there is spoliation in a case, and if that defendant knew and all these elements that were identified in Eddie Potash were there, then it places the plaintiff in a position of losing an expectancy interest. The case of TrawMed was discussed earlier today when the Supreme Court first recognized the tort of interference with business relationships. And the reason that the Supreme Court acknowledged for the first time that tort existed or recognized it in Tennessee was because of this expectancy interest of having a business relationship. It fell short of being tortious interference with contract. But in this case, it's similar because every citizen of the state of Tennessee should have an expectancy interest to be able to come to a finder of fact and present all available evidence to have a fair trial, a fair civil trial.
Okay, thank you. You have your rebuttal time left.
Thank you, Your Honor.
Yes, sir. Will there be one argument on this side or more than one?
Mr. Thomas and I were going to divide our time. I'm going to take 12 minutes. Mr. Thomas is going to take 3 on the spoliation issue, and I'm going to handle the voluntary dismissal issue.
Okay.
And Mr. Fleener represents Mr. Evatt, but he's just joining in the argument.
You just wanted a trip to Knoxville today. It's fine. Thank you very much. It's fine.
Go right ahead, thank you.
May it please the court. My name is Everett Hickson III, and I have the pleasure of representing Gene Matthew Davies, along with Michael Thomas, who represents Premier Boiler, and Phil Fleener, who represents Tyler Evatt. Regarding the voluntary dismissal issue, the trial court was correct to dismiss the entire action pursuant to the attempted voluntary dismissal of a single claim filed by Industrial Boiler, because first, under a voluntary dismissal, the trial court lacks discretion to do anything other than dismiss the entire action. Second, a voluntary dismissal cannot dismiss individual claims from within an action. It only applies to the entire action.
All right, help me out here.
Yes, ma'am.
You filed a motion to dismiss specifically the civil conspiracy claim,
Initially, yes, Your Honor.
and opposing counsel said, you know what, you're right. We shouldn't have pled that. It's the same thing as the statutory claim. What if you guys, which you could have done, was filed an agreed order of dismissal?
I don't think we would be here today if it had been an agreed order of dismissal.
So why does it matter then? I mean, if the result is the same, I mean, the fact that he chose to do it as a voluntary dismissal instead of you guys filing an agreed order, it's the same facts, it's the same situation.
I believe that it's rooted in the notion that the plaintiff is the master of his complaint, and we also have two cases that say you can't dismiss part of a case.
Well, we can argue about that, because justice is a little different. I mean, she had a judgment, she was trying to get damages, and she said, I don't want to get damages, I'm going to non-suit it, and they said, if you're non-suiting it, you can't do that.
That's correct, Your
That
Honor.
that was all one claim, whereas here we've got multiple counts.
That's correct. And in justice, though, the court also looked at Dodson, or Larry E. Parrish versus Dodson, which there was an attempt to dismiss 2 of the 3 claims, but in justice, they explained that the case, by the time it got to the Court of Appeals, all 3 claims were there. So there was never an order entered dismissing any of those claims. So the Court of Appeals in the middle section had the opportunity to say, our holding's limited just to situations where you dismiss a single part of a claim. But the Justice Court elected not to do that. And then Stinson, building upon justice, cited justice for the proposition that you can only voluntarily dismiss an action. Admittedly, Stinson, they sent it back because they couldn't separate the 2 claims, and so, but it was still cited for the same proposition.
Okay, if that's true, which I'm not convinced necessarily that it is, but say that it is, what do you say to his argument then? Well, if that's the case, then I need to withdraw my notice of dismissal because that was clearly not what I intended to do.
Under the authority for voluntary dismissal, the plaintiff is the master of his complaint. The trial judge has no discretion to do anything other than accept the voluntary dismissal.
I don't like this at all.
I understand, Your Honor, and that's why we need clear guidance on this, because an action is an action and a claim's a claim, and they're 2 different things. But again, in Flade versus City of Shelbyville, our Supreme Court explained, although an order is required for a voluntary dismissal, it is not subject to court approval. The plaintiff is the master of his suit, and in most situations, voluntary dismissal can be taken as of right. Then, Walker versus Shelby County in 2023 in the Court of Appeals explains that the trial court is precluded from taking any further action on the matter because, again, the plaintiff is the sole judge of his action. The trial court can't disallow the non-suit. Trial court can't approve it as long as it's subject to the various exceptions that are already within the rule, which aren't really subject here today. And again, back to justice, there was only one claim at issue in justice. But again, as I explained earlier, the court had the option to limit its holding, but elected not to. So, and notably, justice explained an action's an action. You have to dismiss the entirety of it. Let's see. So now there's 2 cases that build upon this notion, which admittedly they are unpublished, but that they're still persuasive authority, and there is no real contrary authority that's been cited. There is Partlow from, I believe, 1838. That case didn't make a lot of sense to me. I would note that Tennessee jurisprudence even cites it for the proposition that you cannot partially voluntarily dismiss a case. Regardless, Tennessee's rules of civil procedure have been noted that voluntary dismissal claims are more liberal than those elsewhere. And then the case explicitly says when they're taken by a defendant, it's a non-suit. Yet even in 1961, the middle section says a defendant can't take a non-suit. So I don't think Partlow necessarily is controlling on this, so there is no real other authority that's been cited that explains this issue whatsoever.
Excuse me, counsel, is
Yes,
there
sir.
a distinction between an action and claims?
Yes, Your Honor. An action has been held repeatedly, including, let's see, Mid-South Pavers from 1989 Court of Appeals. An action is a judicial proceeding at law paralleling a suit in equity. Actions in law and equity in Tennessee are civil actions. That's Rule 2, the Civil Rules of Procedure. And a cause of action is there's a set of facts that give rise to the judicial proceeding. A cause of action is born when the facts occur, and the action occurs when a complaint is filed based on those facts. A claim describes the application for relief. And under Rule 8, you can state as many separate claims for relief as one has. That's also from McCord versus HCA Health Services. And so the rules also explain, the rules show that a claim and an action are different, because there's many times, as I've cited in my brief, the rules say action here, they say claim here. The rules have to mean what they say. We need predictability. If you substitute action for claim, it makes a difference. For example, Rule 1, these rules shall be construed to secure the just, speedy, and inexpensive determination of every claim. Okay? Instead, Rule 1 says action. Rule 3, all civil actions are commenced by filing a complaint. All civil claims. And an action is commenced within the meaning of any statute of limitation. No, a claim. See, those don't work. Likewise, if you look at Rule 8, a party may state as many actions as he has against a party. That, again, these lead to absurd results. The Supreme Court drafted the rules with meaning behind them, and the court has to presume there's meaning behind each rule. And they have to be interpreted together, and the rule words mean what they mean. Let's see.
Well, if it's a dismissal under 41.01, it's without prejudice, right?
It would be, yes, Your Honor.
So they could just refile the whole thing.
Well, if you apply Justice's holding, it was a
But
dismissal.
you're saying it's time barred.
Correct. It would have been either under the original statute's limitation or under the saving statute, but time passed under the various claims, as well as, and they couldn't take advantage of the saving statute, so it would be a dismissal with prejudice at this point. Yes. Let's see. There has been discussion about you should look to other states. I don't believe that's necessary. We have cases that already address this issue. Tennessee's rule is different than many other states, and I believe it would be erroneous to look to other authority to rule differently than what 2 cases within this Court of Appeals have found. Let's see. And as the court's aware, when interpreting these rules, you look at the text. If the text is unambiguous, you apply the plain meaning of the word used. The court's to look at every word, clause, phrase, use and presume that each word was used deliberately, each word has a specific meaning, and the intent was not to enact a useless or absurd procedural rule. That's what gets back to claim and action, and we have to presume they were put in there for a reason. And so, let's see. And there was a question about, does this comport with hearing everything on the merits? I believe it does, because if you file a case late outside the statute of limitations, your case isn't heard on the merits, but that's still an application of rules of civil procedure and statutes. If you have a summary judgment that's granted because your adversary didn't respond to it, that's not being heard on the merits. This is just an application of the rules of civil procedure. I believe, let's see. Words matter. It's key for predictability for litigants to manage their litigation. When the rule says action, it has to mean action. When it says claim, it needs to mean claim. Using those words interchangeably will lead to confusion. So that's why we request the court affirm the judgment below dismissal and remand it with instructions to enter it with prejudice. Thank you for your time.
Good morning, Your Honors. Michael Thomas, Premier Boiler. The premise of our argument is simply that the court should follow Blackstone's theory of the declaratory theory of law. In creating a new tort, it's not whether within the microcosm of a court, whether the facts support creating this claim. Notably, there's been no findings of facts in this case about this issue. This is mere allegation at this point. The declaratory theory of law looks to the history of law. Did this exist? Has this been recognized before? Has there been a similar awareness of this issue in the past? And in the brief, you see that I go back to English common law and cite a case where we believe that the spoliation theory sort of first came into being, involving a lost gem, some jewelry that was found. And when an action was brought in trover to recover that, or the finder of it, to recover it from the jeweler to who he gave it to, the court didn't apply a tort of spoliation. It applied the negative inference test, as Judge Davis was referencing earlier. We have 34A, we have 37, we have all these issues. This has been recognized and considered by the state of Tennessee in reference to more of a negative inference, some sort of the judge stepping in as an issue of law and finding a sanction that's appropriate in that given situation. English common law was unable to find spoliation as a tort. And maybe your clerks are a little bit better at me in research, and I'm sure you'll sick them on it, but I don't mean to joke about that, but I just couldn't find it. And I don't like to use the word I when I'm arguing, but unfortunately I was in the position to where I was the one researching this and just could not locate it. In fact, when you did look at what was existing in the state of Tennessee, we go back to the Rules Committee that was created. The Supreme Court put down these rules. We had an agreement to create this Rules Committee, and the legislature gets to put its final stamp on it. Spoliation has been considered in this aspect of a sanction, of a jury instruction. In fact, it's such a complicated subject that the TPI put a forward to this issue to make sure that we are applying the proper sanction for spoliation in any given situation. That way you didn't have one set of facts being interpreted 2 or 3 different ways within the consideration of the TPI. And notably, since the legislature did consider the Rules Committee, did consider these rules of civil procedure when putting a stamp on it, it goes to say that they also could have considered that as separate litigation, legislation, separate consideration for a new tort that it could have been created statutorily, which they didn't do. So here we have, going back to the beginning in English common law, where we have sanctions, where we have inferences, where we have pseudo-jury instructions being created at that time, and no point up to today has there been a tort in the state of Tennessee. And the closest we could find is looking to North Carolina, when it was more of an obstruction of justice finding that they found over there on how to interpret a spoliation issue. So circling back to the declaratory theory of law, it didn't exist, it hasn't existed. Moving forward, our legislature has considered the issue, but has elected, we would assume, to not create this tort statutorily. And now we have here a situation where a court in Chattanooga, Tennessee, trial court, has created this statute on its own, and in its ruling essentially said, well, we have more opportunities for spoliation today because of electronic situations and people being able to delete texts and such, that we need to create it. But that ruling was not based in any history or any doctrine that existed in Tennessee to this date, and even going back to English common law and North Carolina as part of the original 13 colonies hadn't existed. Only 6 states in the United States have considered it, and I believe, I could I have to review my records, there's a mens rea requirement, this intentional act that follows with it. So, do y'all have any questions with 2 seconds left to go?
I hear none.
Thank you. I appreciate your considerations, Your Honor.
Sure thing. Yes, sir, your rebuttal.
Thank you, Your Honors. In rebuttal, one thing that I think is important to note, both about Justice versus Craft Deconstruction and Stinson, is that they both had one cause of action. In Justice, that cause of action was breach of contract, breach of real estate contract, in which the remedy was either damages or specific performance. And so what the court was saying in Justice is that, look, you can't just dismiss your remedy without dismissing your entire claim. So the same applies.
What about their
Yes, sure.
plain language argument, basically, that 41.01 talks about dismissal of an action as opposed to specific claims?
Your Honor, it's a good argument. It's a good argument, but that argument takes the rule, one word out of that rule, the word action, and causes that word to affect the entire application of the rule while ignoring the entire common law that rule is based on. And that's not what that rule was designed to do. Rule 41.01 is unique among other rules in the rules of civil procedure. It's unique because it finds its roots in the very fabric of Tennessee law, from the early portion of Tennessee law's statehood. And the Partlow case was mentioned earlier, and I think it's good to look at what the court actually said in Partlow. It was a Supreme Court case, and what the court was doing was explaining the history of non-suit and nolle prosequi, which was a cause of action at that time, or was a procedure at that time to dismiss distinct causes of action before they were submitted to the trier of fact. It was similar to what a prosecutor could do when they drop charges against a defendant. But in that case, the court said, and I'm quoting from the opinion, if then the plaintiff can enter a nolle prosequi as to one count of his declaration and proceed on the others, which he most unquestionably can, he can also do the same by a non-suit. And this, although most of these cases involving partial non-suits are in sort of the ether or background of cases rather than being hit head-on in an analysis by the courts, with Partlow being an exception, there's been cases that have come up to the Court of Appeals, and the Court of Appeals has looked at this issue, including Gersper versus Turner. Actually, it was a Court of Appeals case from October of last year. In that case, there were 3 claims that the party made. Number 1, malicious prosecution. Number 2, defamation. Number 3, tortious interference.
Okay.
And in
I
that
think your
case,
time is about up, sir. You can finish your point, but go ahead. I'll let you do that.
thank you, Your Honor. In that case, the plaintiff dismissed the latter of the 2 claims, leaving only the malicious prosecution claim. That went up to the Court of Appeals. The Court of Appeals found no error and did not dismiss it for lack of subject matter jurisdiction.
Thank you.
Thank you, Your Honors.
I want to thank all the attorneys for your presentation. Your case has now been submitted to this court for resolution. You should receive our opinion and judgment